Subcommittee on Courts, Internet, and Intellectual Property will come to order. And I'd like to begin by welcoming everyone to this hearing. Stifling or stimulating the role of gene patents in research and genetic testing. I noticed a couple of days ago that George Bush, when he was talking about President Putin and some of the problems, he said in terms of whether or not it's possible to reprogram the kind of basic Russian DNA, which is a centralized authority, that's hard to do. And so I'd first like to know if there is a patent for an authoritarian gene, and how does it express itself, and can it be licensed? Scientific knowledge concerning genes has expanded considerably in the last half-century since James Watson and Francis Crick put forth their discovery of DNA. We'll put aside Mr. Watson's social views for a moment here. We know now that genes are the blueprints of all living things. I'm told that genes are chemical instructions stored in our cells that tell our bodies to grow bones, make blood, repair damaged skin, and perform tens of thousands of other functions. Efforts to map the human genome, like the Human Genome Project headed by NIH, has allowed us to identify specific genes, determine their function, and harness their usefulness. As a result, we have been able to produce therapies to alleviate human suffering, such as insulin, develop tests to determine susceptibility to diseases like Alzheimer's and breast cancer, and create wholly new organisms like cancer mice and pesticide-resistant plants. Many attribute this success to the incentives provided by the patent system. Given the robust nature of the commercialization of biotechnology research, it's fair to say that patents have done their job in promoting new inventions in this field. However, there are those that have raised concerns about the impact of providing exclusivity for patents on genes. For some, genes are thought of as products of nature and thus should not be patentable subject matter. However, the courts have long held that compositions of matter, isolated and purified from their natural state, are worthy of patent protection. This principle was made clearly applicable to living matter like genes in the Supreme Court's Diamond versus Chakrabarty decision. For some, gene patents should require a more rigorous review. The USPTO revised their examination guidelines for gene patenting in 2001, which strengthened utility requirements so that a gene could no longer be patented based on uses like being good for landfill. But while the 2001 guidelines tightened patentability requirements, some continue to argue that many gene patents are still issued for uses that are speculative and unproven. If the quality of gene patents remains a problem, stricter utility standards requiring more concrete uses may be called for. However, any lingering quality issues surrounding how gene inventions are examined could very well be impacted by the recent KSR versus Teleflex decision. I know one of you, at least one of our witnesses, will be speaking to that issue. Still others fear that gene patents will be used to hinder research. They argue that if patent thickets were to form, it would become too costly or too troublesome for researchers to license the patented inventions they need, forcing them to abandon their research. There is anecdotal information that supports this notion, that researchers have discontinued research pursuits because of the threat of lawsuits by gene patent holders. However, there's also data that suggests just the opposite. The gene patents have had little impact on basic research. A recent survey by the National Academy of Sciences found that in biomedical research, there is a lack of substantial evidence for a patent thicket or a patent blocking problem, end of quote, primarily because researchers aren't very concerned about patents being enforced against them. However, the report went on to say that this nonchalant attitude was based on the assumption by many researchers that they qualify for a robust research use exception, which many believe was eliminated by the 2002 Maddie versus Duke decision. Regardless, it might only take one major victory against a university to create a real and substantial chilling effect. As such, we may need to examine the effects or necessity of a clear research use exception. Finally, for some opposition to gene patents as a matter of principle, they point out that patents on genetic tests is harming patient access to and stunting improvement of these tests. It is reasoned that since most insurance providers do not provide coverage for genetic tests, the patent markup can price tests out of reach for many patients. In addition, some claim that gene patents have been asserted in order to prevent others from improving possibly inaccurate genetic tests and identifying whether the tests are even applicable to certain population subgroups. While I firmly support a patent holder's right to charge what the market will bear for his invention, using a patent to block efforts that check the efficacy of such tests borders on the realm of patent misuse and may constitute anti-competitive practices. Patents are meant to encourage technological progress. Thus, it is antithetical to the patent system for companies to use their patents to freeze a technology at a particular stage of development. But is that what is happening? Are the practices of a few unfairly coloring all gene patents in a negative light? Are complaints related to gene patents based more on how they are being used instead of what is being patented? We need to examine the role gene patents play in stimulating or stifling research and genetic testing. It's my hope that this hearing will help us answer these and many other underlying questions. It's now my pleasure to recognize my friend and colleague, the distinguished ranking minority member of the subcommittee, Howard Coble, for his opening statement.
Thank you, Mr. Chairman. This is, and ladies and gentlemen, this is a good hearing topic, Mr. Chairman, in large part because the subject matter lends itself oftentimes to misrepresentation. At the outset, it seems to me that an inventor whose application satisfies the requirements for a gene patent isn't trying to patent, quote, life, close quote, or personal DNA chemistry in violation of the 13th Amendment. The inventor's ultimate goal is to develop a protein-based drug, a diagnostic test, or therapeutic modality that will improve public health, if not save lives. I therefore hope the subcommittee will collectively acknowledge after this hearing that gene patenting is a legitimate part of our patent system. It is a thriving component, it seems to me, of our knowledge-based economy. More importantly, gene patents ultimately contribute to the health and welfare of the American people and patients all over the world. The National Institutes of Health is the world's largest agency for conducting basic medical and biological research with a budget in excess of $28 billion. But the pharmaceutical and biotech industries devote more than $50 billion annually to research. The process of identifying a DNA sequence through clinical testing and manufacturing of an FDA-approved drug may cost the patent holder in excess of $1 billion. Yet only a third of all drugs ever generate revenue sufficient to cover those costs. And a great majority, I am told, Mr. Chairman, of the biotech companies do not realize a profit. Mr. Chairman, you did a very good, masterful job, I'll say, in negotiating the recently passed Patent Reform Act of 2007. And one thing we learned while debating that legislation is that different industries employ different business models that use the patent system in various and sundry ways. American biotech companies are more reliant on the Patent Act than any other industry. While a few biotech companies are large, most are smaller and lack the internal financing resources to subsidize their drug research and development. This is especially true of small startup companies whose valuation is an exclusive function of their patent portfolios. At our hearing today, the witnesses and the subcommittee will explore some legitimate topics associated with gene patents. Are gene patents an impediment to university research? Do they inhibit competition and limit patient access to diagnostic testing? Should the government exercise march-in rights to promote greater testing and research? I look forward to the testimonies of our witnesses today on these and other issues. And in conclusion, Mr. Chairman, on March the 14th of 2000, about 4 months before you and I were involved in a subcommittee on this very issue, a hearing on gene patents and genomic inventions, I remember President Clinton and Prime Minister Blair issued a joint statement on the human genome. They said that all genes in the human body should be made freely available to scientists everywhere, and some interpreted that as an announcement of new government policy that genes could not be patented. And then the biotech industry, of course, experienced bad difficulty, losing several $1 billion. And the following day, the White House released another statement emphasizing that the administration supported the patenting of genes. I guess the moral of the story, Mr. Chairman, is to proceed cautiously and deliberately. And you have a good reputation of doing that, and I think I do too. This is a good topic for an oversight hearing, but I think we must exercise great care about legislating in this area, lest possibly important industry and compromised public health could result. Thank you, Mr. Chairman.
Thank you, Mr. Coble. I'm wondering whether the asset value of the companies went back up by $2 billion on the next day when he said that, because if he can, then I can say anything now and correct it tomorrow.
And I'm not sure I can answer that.
I now introduce a very distinguished panel of witnesses. Well, first, other opening statements? All right. Lauren Sung is director of the Intellectual Property Law Program at the University of Maryland School of Law. He is a partner in the Washington, D.C. office of Dewey and LaBeouf, where he specializes in biotechnology, medical device, and pharmaceutical patent litigation and counseling. Additionally, he serves as a consultant to the National Human Genome Research Institute and as chair for intellectual property concerns for the National Research Council. Professor Sung earned a PhD in microbiology from the U.S. Department of Defense, Uniformed Services University of the Health Sciences, a JD from American University's Washington College of Law. John Soderstrom is the managing director of the Office of Cooperative Research at Yale University, where he is responsible for managing the university's intellectual property portfolio, executing commercialization strategies, and developing spin-off ventures. His posture has allowed him to participate in the formation of more than 25 new startup companies, many in the biotechnology sector. Prior to joining Yale, Dr. Soderstrom was the director of program development for Oak Ridge National Laboratory. Dr. Soderstrom is also president-elect of the Association of University Technology Managers. Dr. Soderstrom received his PhD from Northwestern University. And I might point out we've had no less than the president of Yale University testifying on patent issues several times in the past few years. Mark Grodman is founder of BioReference Laboratories, the largest clinical laboratory operating in the Northeast. In addition to being a major regional laboratory, BioReference Laboratories also provides national services in informatics and genomics. Dr. Grodman is also an assistant professor of clinical medicine at Columbia University's College of Physicians and Surgeons. Dr. Grodman received his BA from the University of Pennsylvania, his MD from Columbia University, and attended Harvard University's Kennedy School of Government. Jeffrey Kushan is a partner with Sidley & Austin, where he serves as practice group chair for the firm's D.C. office. Mr. Kushan focuses his practice on Hatch-Waxman patent litigation, patent appeals and proceedings, patent portfolio reviews, and he represents clients, including trade associations, on domestic and international patent policy matters. He is testifying today on behalf of the Biotechnology Industry Organization. Before entering private practice, Mr. Kushan worked in government as a patent examiner in various policy advisory positions at the USPTO and as an IP negotiator at the USTR. Mr. Kushan received his MA in chemistry from the University of North Carolina at Chapel Hill and his JD from George Washington University. Gentlemen, it's really an honor to have you all here today. Your statements will be made, your written statements will be made part of the record those statements in their entirety. I'd ask if you would be willing to summarize your testimony in 5 minutes or less, and to stay within the time. There's a timing light at the table. When 1 minute remains, the light will switch from green to yellow, and then red when the 5 minutes are up. We're glad to have you here. Dr. Sung? Is that mic on?
My charge during our brief time is relatively modest. I'm not here to represent an organization, nor am I here to press an agenda. Rather, I hope to help inform your deliberations on gene patenting with insights about the nature of patent protection for genomic inventions, and also to describe some available options that might assist in effectuating the particular balance between patent exclusivity and public access you ultimately deem appropriate. These may not be actual answers to the question of gene patenting, but then, as you know, what law professors do best is to answer a question by raising more questions. This subcommittee has had the benefit of hearings focusing on the state of the patent system and on the possibility of patent reform legislation. I will not revisit these general principles of the patent system, but instead address some of the distinctions about gene patenting. 3 in particular. First, patenting genomic inventions is different because the underlying technology is different. Metaphorically speaking, in the physical sciences, if one dedicates her career to climbing the highest mountain, then on that day, she can be confident that she has seen all there is to see. By contrast, in the biological sciences, once you summit the highest mountain, only then do you see that there are other mountains you've never seen before. The science in this field is fluid, and this creates an inherent tension with the patent system, which, like other systems of legal rights, depends upon static definition. Gene patents define this type of containment. Second, genes are simply something that we have a sense should be part of the public common. That the subject matter might fit within the legal standards of what is patentable does not necessarily change the fact that many are left feeling that something is just not right about treating genetic information as property. Third, the temporal distortion that exists between the time one files a patent application and the time the courts adjudicate those patent rights seems even greater when dealing with gene patents. Sometimes decades separate these two events. And when courts make pronouncements today about what was a fledgling technology 20 years ago, that does not sit well with a public that sees foremost what is at stake today. Now, the state of gene patenting has seen significant evolution. When technology developed to allow rapid gene sequencing occurred, patent claims began being filed in hordes, what some called the patent gold rush. But like most gold rushes, virtually all of the claims were speculative, and the prospect of great wealth became illusory. The Patent Office wisely issued a moratorium on examination until setting forth revised standards of utility and written description that could be applied more sensibly to patent claims to DNA fragments known as express sequence tags, or ESTs. This era concluded with a 2005 Federal Circuit decision in Ray Fisher, which clarified that DNA fragments without some demonstrated knowledge about its biological relevance were not patentable for failure to teach a specific, substantial, and credible utility. This case arguably alleviates much of the wild concern over what many generically and inaccurately call gene patents. To be clear, gene patents still exist, but there are claims for DNA for which we have been taught both what it is and what it does. And this is somewhat more acceptable than the EST patent claims that the public first rallied against. But the issue of gene patents and their effect on research and public access to genetic testing remains. For those of the mind that action is necessary, one option is the maintenance or the enhancement of the rigor with which the Patent Office examines gene patent applications. The involving jurisprudence generally in the patent law doctrines of anticipation, inherency, and obviousness, including the Supreme Court's decision in KSR versus Teleflex, combined with the existing disclosure requirements of written description and enablement, suggests that fewer gene patents will pass muster. In addition, the Supreme Court decision in Merck versus Integra will likely lessen the ability of certain patents, including some gene patents, to be enforced. The Supreme Court decision in eBay versus Merck exchange also implicates the restraint on the grounds of public interest in granting injunctive relief to gene patent plaintiffs even where infringement has occurred. The government's implementation of existing march-in rights for federally funded technology covered by gene patents would be another avenue to ensure public access. For those that feel the status quo or the reinvigoration of these standards falls short, new legislation might be considered, and these include 3 options. First is the creation of a heightened standard of inventorship that effectively precludes the mere elucidation of natural property, such as a DNA sequence or a biological pathway. Second is compulsory licensing of gene patents or some form of mandatory patent pooling of gene patents. And third is an academic research use exemption from patent infringement. In this last regard, my written submission for this hearing details a proposal of an elective right to use patented technology. I appreciate your attention. In closing, I ask your indulgence to be mindful that in the brief time here, I have necessarily oversimplified many aspects of a complex set of considerations. As I caution in my written statement, generalization is problematic with regard to gene patents, and I hope you'll seek further insights of others on the important specifics. Thank you.
Thank you very much, Dr. Sung. Dr. Soderstrom?
Thank you, Mr. Chairman, for the invitation to be here today. As you indicated in your opening statement, some scholars have argued that patents and their enforcement may impose significant costs upon non-commercial biomedical research by creating an anti-commons or a patent thicket that may make the acquisition of licenses and other rights too burdensome to permit the pursuit of these otherwise scientifically and socially worthwhile research. These concerns have grown since May v. Duke, a decision that affirmed the absence of any research exemption shielding universities from patent infringement liability. But without diminishing the importance of these potential concerns, it should be pointed out that the evidence offered to support these contentions is primarily anecdotal. And I need not remind you that the plural of anecdote is not data. Although a few isolated incidents have received significant attention, there is little systematic evidence that widespread assertion of patent rights on genes has significantly hampered biomedical research. Two recent surveys, as you pointed out, offer little empirical basis for claims that restricted access to intellectual property is currently impeding academic biomedical research. The authors, in fact, further note that patents are not typically used to restrict access to knowledge and tangible materials that biomedical scientists require. The surveys further show that firms generally do not threaten infringement litigation against academic research institutions, a de facto research exemption, if you will, in part because such academic use may improve their invention, or because they wish to maintain goodwill and ensure access to future academic inventions, and also because the damages, as we all know, are likely to be very small. These studies also confirm that university technology managers take a very nuanced approach to patenting and licensing, seeking only enough intellectual property protection to facilitate the commercial development of an invention. Decisions to patent and strategies for commercializing the inventions depend on a determination of the level of protection necessary to induce an interested company into investing in the further development, testing, manufacturing, marketing, sales of a product embodying the technology. But these results should not be surprising. The practice of university technology transfer managers reflect the salutary effects of the guidance that the National Institutes of Health has issued on patenting of research tools and genomic inventions, as well as the formation of professional norms and standards of behavior encouraged by groups such as the one that I help lead, the Association of University Technology Managers. Universities share certain core values, and we seek to maintain to the fullest extent possible in all technology transfer agreements. Chief among these values are the protection of academic freedom and the open pursuit of scientific inquiry. We seek balance between the business needs of our licensing partners and these shared values of our respective academic institutions. Recently, a group of university research officers, licensing directors, and a representative from the Association of American Medical Colleges recognized the need to clearly articulate a set of principles that strike such an appropriate public policy balance. The participating universities released a white paper in the public interest, 9 points to consider in licensing university technology. These considerations were put forth in an aspirational or self-correcting sense to encourage the profession to set a high standard by creatively stretching the boundaries of conventional licensing practices and ensuring that licensing activities are in the public interest for society's benefits. The 9 points included: 1, universities should reserve the right to practice licensed inventions and to allow other nonprofit and governmental organizations to do so. 2, exclusive licenses should be structured in a manner that encourage technology development and use as broadly and as quickly as possible. 3, that we should strive to minimize the licensing of, quote, future improvements. 4, that universities should anticipate and help manage technology transfer-related conflicts of interest. 5, ensure broad access to research tools. 6, enforcement actions should be carefully considered. 7, we should be mindful of export regulations. 8, we should be mindful of the implications of working with patent aggregators. And 9, we should consider including provisions that address unmet needs such as those of neglected patient populations or geographic areas, giving particular attention to improved therapeutics, diagnostics, and agricultural technologies for the developing world. Many of these points were already being practiced. In fact, the 9 points have been endorsed by a growing number of academic institutions and professional organizations around the world. We applaud these participating universities' efforts to articulate these important principles and urge their adoption and application by the wider community of universities. In the end, we hope to foster thoughtful approaches and creative solutions to complex problems that may arise when universities license technologies in the public interest and for society's benefit. We believe that patent policy, as well as practice, should be guided by the goal of promoting innovation and, in turn, improvements in human welfare. That view drove Yale's interest in helping to draft the 9 Points Guidelines, which recommended that universities endeavor to make genomic inventions that will serve primarily as research tools as broadly available as possible. Yale has long taken a balanced approach to patenting, taking into account the nature of the invention, its relevance to research, and the extent to which patent protection would necessary to give a commercial partner adequate incentive to develop the product completely. We have taken a similar approach to licensing, especially by insisting that the right to make inventions available to researchers at Yale and other academic institutions. We do not think that gene patents are having a significant negative impact on academic research. There have been thoughtful analyses of problems that could arise, but the most comprehensive studies of this issue concluded that the patents are not slowing the pace of research. Yale and other research universities have a major stake in ensuring access to research tools. We also recognize the circumstances may change as the field of genomics and proteomics continue to advance, and I am confident that the scientific community, working with the National Institutes of Health, the Association of Technology Managers, the Association of American Medical Colleges, and others, will continue to monitor whether gene patents are interfering significantly with research. My colleagues and I gratefully for the subcommittee's interest in this topic. Thank you.
Dr. Grodman?
Mr. Chairman, members of the subcommittee, I want to thank you for the opportunity of testifying on a critical issue of public health. My name is Mark Rodman. I'm a physician, as well as founder and CEO of BioReference Laboratories, a publicly traded company. We're the largest independent regional clinical laboratory in the Northeast, employing over 1,700 people with revenues this year that will exceed $250 million. In 2006, BioReference Laboratories purchased GeneDx, a laboratory in Gaithersburg, Maryland that does primarily genetic testing. This was an important business opportunity. Unfortunately, the ability of GeneDx to offer potentially life-saving genetic tests have been severely restricted. Gene patent holders have granted exclusive licenses for the testing of genetic disorders, keeping competitors like GeneDx out, and we think having an adverse effect on the public. I am not here today to attack the patenting of genes. What I'm here to say is that using gene patents for the exclusive licensing of genetic tests, such as conditions as in cancer or neurological disease, certain kinds of heart disease, among others, should be severely restricted, if not barred. A laboratory with an exclusive testing license doesn't have to compete. This results in substandard quality of the testing, as well as excessive pricing, making the test unaffordable to many. It also stifles research and innovation. Competition, on the other hand, is the most effective tool we have to address the needs of public health. Let me describe 3 examples that will explain what I mean. The first example concerns one of our society's most dangerous killers, breast cancer, and the related breast cancer genes BRCA1 and BRCA2. The patent holder has granted an exclusive license to one company to do the diagnostic testing for this disease, for these genes. Not surprisingly, over the course of time, quality issues arose. Dr. Chung from Columbia University, who has submitted testimony along with my testimony, cites in her testimony that for about 10 years, the test for breast cancer genes was not as comprehensive as it might have been, given that there were a number of subsequent mutations that were not found. Competition would never allow this situation to go on. And in fact, this information is confirmed in a peer-reviewed article, which is also cited in Dr. Chung's testimony. The second example involves long QT genes that can cause sudden death from heart arrhythmias. These genes were patented, and an exclusive license was granted to a single laboratory. For 2 years, the exclusive licensed laboratory went into bankruptcy, and no other laboratory could test for this gene. During this hiatus, Abigail, a 10-year-old child with long QT syndrome, died. There's not just one or two genes. Each of the genes may mean a different medicine may work. So you really have to do it and do it well. And in the period of time, this girl never had access to the test. Dr. Chung also describes persistent problems with the test performed by this exclusive laboratory, including long delays in getting results, indeterminate findings, high costs, and just the basic lack of improvement on making the test better. We can make a better test, but under the existing system, we can't. The third example is raised by testimony that I submitted from Dr. Kathy Matthews, a child neurologist and pediatrician at the University of Iowa. Dr. Matthew describes serious quality issues that she's encountered with the exclusive licensing of laboratory tests for certain neurological disorders. Somewhat amazing that as time goes on and we learn more about the association of different medical conditions and genetic patterns, that she's now at a point to where she's referring less. These scenarios illustrate another problem, that the laboratory with the exclusive license has no incentive to conduct further research, or other laboratories are including academic laboratories, are prevented by the patent holder from doing research as well in many cases. I believe that competition in diagnostic testing is critical to protecting the public health. And fortunately, there's a remedy, aside from legislative reform, and that's the Bayh-Dole Act of 1980. This is the act that allows universities to get paid patents on genes even though federal funds helped pay for the research. The act, however, recognizes that the patent monopoly obtained through taxpayer funding could be misused. It specified specifically a remedy. When the public's health or safety needs were not being reasonably satisfied by the patent holder or its exclusive licensee, the federal funding agency has the power to march in and provide licenses to other interested parties. Thus, under existing Bayh-Dole legislation, when there are legitimate health and quality complaints about genetic laboratory tests of an exclusive licensee, the NIH may give licenses to other laboratories willing and able to do the tests. Opening up the licensing process to more than one diagnostic testing laboratory will have the desirable benefits of improving quality, more research, lower price, and creating a competitive framework and a higher standard by which even the exclusive licensees have to be able to attain. As a laboratory, we're not seeking any windfall. Under Bayh-Dole, any laboratory given a license through the margin provisions can and should be charged a reasonable royalty to use the patent. Even though the NIH has refused to march in 3 instances which it was asked to do so, those cases involve drugs and not gene diagnostic testing, and involved issues of price, not efficacy. Therefore, Congress must compel the NIH to enforce the margin provisions of the Bayh-Dole Act. In conclusion, if we or any company can be able to provide a faster, better, or thorough results, more complete, more efficient test to the public, the ability to go in and obtain this on a non-exclusive license and entering the market will be in the public health's advantage. Thank you very much.
I now change your name to Mr. Cushion.
Thank you. Thank you, Mr. Chairman. I'm pleased to be here today to provide the views of the Biotechnology Industry Organization on the issue of gene patents. BIO is the principal trade association representing the biotechnology industry. There are more than 1,100 members of BIO. You can find them in every state of the union, and they presently employ more than 1.2 million people in the United States. Biotechnology is still a young and growing industry. There are about 300 public companies in the biotech industry. At the end of 2005, their market cap was about $410 billion. The remainder of the companies in the biotechnology industry are private companies. The typical biotech company is a small business with no products, no revenues, and running itself on investor funding. Many of these companies were formed to take advantage of a significant scientific discovery or development. These companies focus on performing cutting-edge research aimed at discovering new products and services and bringing them to market. They follow a high-risk, high-reward business model. This model has been a signature of the industry since its inception. 3 fundamental requirements exist for biotech companies that are following this business model. First, scientific innovation, second, adequate funding, and third, dependable intellectual property protection. I've chosen the word dependable in relation to intellectual property intentionally. When a biotech company develops an invention, they must make a judgment on whether the invention can be patented and whether these patent rights can be effectively used when and if they finally get a product to market. That judgment is based on existing legal standards and an assessment of the prior art. This certainty in the availability and use of patent rights in the future is critical given the uncertainty that exists on the scientific side of the business and whether they will ever reach the market with a product. Today's discussion is focused on gene patents. The word gene patent, as some of the other panelists have already pointed out, is somewhat imprecise. What's at issue are patents that claim nucleic acids. Nucleic acid inventions are developed following extensive research and development. They rely on sophisticated research in the on genomic information. The research focuses on deciphering that genetic information and identifying a practical application for using the nucleic acid. It's important to recognize this is not a debate about the quality of these patents. This is perhaps the one area of the Patent Office that is the most competent, the most high quality of all the areas. The PTO for more than 20 years has been doing extensive research on developing its own first-class examination group. You have more PhDs in the biotech group than any other area, and they certainly know their stuff. And one of my other co-panelists have mentioned that the standards governing patent law in the biotech area have evolved significantly over the last 20 years. I think one thing we can assure you of is that when a patent issues in the sector, it is reflective of a significant advance. The company is deserving of the protection, and that will be used to develop products and bring them to market. There are 3 points that I feel need to be addressed today. First, the biotechnology industry is an extremely competitive and it's a lucrative business. That dynamic is going to create conflicts no matter how you look at it. It's good for companies to have competition. It's also good for companies to be able to develop their own technology, protect it, and rely on patents to do so. You also have to appreciate that the competition is making the industry healthy and strong, and it's also delivering significant benefits for patients as products reach the market. Without that lucrative drive for the incentive for a reward on innovation, you won't see the products coming to the market. You won't see the technology reaching the market in form of valuable products and services. It's also a fact that conflicts arise whenever you have a lucrative competitive market. Patent conflicts also are common in this world, and the biotechnology industry accepts that as part of the equation of doing business in this environment. Given the dependence on patent rights and the acceptance of the industry that there will be need to resolve disputes over property rights, we are very concerned that there might be some tinkering of the patent system that would alter the equation that so many companies have relied on before they made their investments. The second point that was raised was the question of using the Marchand rights under the Bayh-Dole Act. In the mid-90s, there was some thought to using that authority in the Bayh-Dole Act to regulate pricing of pharmaceutical products. The only impact we could see from that is that the private companies ran away from the federal funding, because to attach a string like that upstream to invention of a product before you took the funding from the government basically made that a non-starter for the companies looking at that source of funding. Third is to just touch on the research exemption. I think what we've seen, and Dr. Soderstrom had pointed this out, there's very few instances of patent owners suing universities for many of the reasons he's already pointed out. The Mady v. Duke was kind of a weird case involving a particularly unhappy patent owner with an employment dispute with Duke University, and I don't think it reflects or is a representative fact pattern that most companies who hold patents see when they're dealing with universities. So I would just like to conclude in encouraging the committee to look very carefully at the issue of gene patents, and to also carefully consider what impact upstream, downstream that might have if you start to look at changing some of the parameters that companies have relied on before they made their investments in the sector. Thank you.
Well, thank you all very much. I'll recognize myself for 5 minutes to begin the questioning process. Dr. Sung, you propose in your written testimony a very specific legislative proposal that creates a research use exception. One problem I've heard often in designing a research use exception is being able to draw a bright line between commercial use and a research use of an invention. How did your proposal deal with that issue?
Well, Congressman, I should say that the research use proposal that I'd laid out in my written submission was used as a piece for further discussion points about that very aspect of it. I don't think that it has been traditionally very easy to make that delineation between commercial and non-commercial use. In fact, the focus of the Federal Circuit opinion in Mady versus Duke related to that difficulty. That being said, the proposal therefore takes it and makes it a selective opt-in process, whereby it is a self-identification issue on the part of entities interested in engaging in that type of quote-unquote academic research use. And to the extent they are willing to self-identify, there would need to be some transparency and accountability for what they plan on doing through the submission of a detailed research plan. This is not meant to put both the academics and the private industry at odds, but hopefully to help foster a more open working relationship between the two for that purpose.
So the researcher opts in and then has some kind of transparent process submitted to what, the PTO or?
Actually, it could be a notice directly to the patent owner for that purpose, and again, to facilitate the dialogue. Now, some may say that it's problematic because oftentimes researchers would not know about a patent in existence, much less the patent owner, and the reason this is drafted as an opt-in procedure is you could certainly rely on status quo and conduct your affairs accordingly.
Mr. Cushion, you say that any change to the law regarding gene patents would negatively affect expectations by investors in biotechnology companies. You also indicate that the biotechnology industry has had a long tradition of refraining from asserting their patents against universities, and you point to data that supports this. Since the biotechnology industry does not sue universities that are making research use of their gene patents, would legislating a clear research use exception upset investor expectations? Wouldn't an explicit research use exception for gene patents just codify an already existing practice and therefore be of no real importance to investors?
Well, as your past 3 years of effort in carefully drafting patent reform has shown, the words you choose to articulate that line will be very difficult to write down and to make sure they do not have an overbroad or underbroad or unintended consequence.
We won't use a second window.
I think it's fair to say that this has been kind of an academic question that we've seen for the past 15 years, whether it's necessary to create this kind of statutory bright line to shield purely academic research. One of the challenges we see is that we very infrequently see purely academic research. I think one concern that can immediately come up is if you have an academic researcher who's sponsored by your biggest competitor running programs intending to make an infringing product, we wouldn't want to see a statutory research exemption somehow shield that person from the commercial liability they're going to create. And I think as you go through some of these types of scenarios.
Why would it? Take Dr. Sung's formulation. The researcher opts in and then tells the patent holder, even though he's being asked to do this by the potential competitor, exactly what he's doing, and the patent holder is sitting there watching to see the day it goes from research into commercial development and whacks him not only for infringement but for breach of contract.
Well,
or whatever.
I'll go back to kind of whether that would ever happen. First, there's two scenarios that are out there in this example. One is that a researcher who's doing purely academic research is going to be concerned about a patent and liability from that. And I don't think there are many researchers who do purely academic research that believe that they're at risk. The second scenario is if there is really a commercial motivation driving that researcher to kind of step up and put yourself squarely in the headlights of a patent owner, would not be recommended by most attorneys representing the company that's sponsoring that research because it'll create unnecessary risks. I think as a practical matter, we see very few instances of patent owners going after purely academic research, both because there's very limited damages at the outset. You know, the work that's being done doesn't reflect the kind of scale.
Well, my time has expired, but.
I'm sorry.
But you say they very rarely go after purely academic research, and then you say, but they really don't do purely academic research.
Well, that's part of the challenge of drawing that line you're trying to draw. I think if it's truly academic research, there's nothing they should be concerned with. If it's something that is not, if it's a sheep in wolf's clothing or a wolf in sheep's clothing, then you shouldn't really be shielding that activity under a research exemption because it's not appropriate to do that. That's actually commercially competitive type of scenarios.
Thank you. Mr. Coble.
Thank you, Mr. Chairman. Let me direct this question to all the witnesses. Are most of the complaints about gene patents based on isolated incidents or anecdotal evidence? The appendices of Dr. Grodman's testimony cite some disturbing cases. Now, I'm wondering, is there a systematic problem with the exclusive licensing of genetic associations? Mr. Grodman, why don't I start with you?
Thanks. In the testimony, we both have in there both peer-reviewed article. There was one article that from JAMA that talked about breast cancer specifically and talked about in those areas where there were 2 genes that were found out, that scientific research said that there were other areas, other insertions, genetic rearrangements, and mutations, that in fact that 17% of the cases, which was seemed to be negative, were in fact positive when in light of new studies. But in the cases of the one laboratory doing the test, there was not the same incentive or urge to be able to go up and update the test as if there was another laboratory that was keeping it up to date. There also were in there specific cases of where when results come back in an indeterminate manner, which is something that no degree of regulation could attach, could be able to deal with, that in those cases, it's up to between the referring geneticist and the doctor and in the laboratory to come up with a satisfactory result. And in that case, that geneticist who referred the test had nowhere else to go for the test. So the concern is that exclusive licenses in diagnostic gene testing, we believe, does lead to a situation of where there is no proper competition or urge to produce a better service.
Mr. Cushion, let me ask you this. What would happen to the biotechnology industry if the federal government exercised march-in rights on a regular basis, A, and should the standards of Section 203 of the Patent Act be amended to encourage greater use of march-in rights?
Those are two difficult questions, and I'll do what I can to respond to that.
Well, you're a Carolina man. That's why I put it to you.
Thank you. I noticed my Carolina blue tie. I think the first question of the use of the march-in authority would have a fairly significant chilling effect on the biotech industry, in part because the political decisions that might drive use of that authority are very scary to companies that have invested money in developing a product. The idea that you're going to do all this work, spend all this money, finally reach the market, and then at the back end of your business model, an uncertainty that you couldn't have imagined will pop up and deprive you of the patent exclusivity is going to have an impact on use of those funds. The second part of this is that we have seen the NIH take steps in the past decade to use their influence without the march-in authority to set standards of conduct. For example, they developed guidelines relating to use of materials and sharing of research tools when there had been federal funding involved in that. And that's kind of a better model of essentially putting on the table that before you take the funding, you know that there will be conditions attached to it. I think when you look at the march-in experience, the fact that they have never been used and that there is so much reticence about going to that as a mechanism has created a fairly significant set of expectations in the industry that they won't be used at the back end in the commercial setting.
Thank you. Before my time expires, let me go to Dr. Sugg and/or Dr. Sundstrom. We have compulsory licenses in the Copyright Act. Why shouldn't we have compulsory licenses for patented pharmaceuticals and biologics? Either of you two.
I would simply echo many of the comments that Mr. Cushion just made, in that when we are negotiating licenses, particularly to startup companies, to biotech companies, this issue comes up all the time. What are the government reserved rights? What are march-in rights? How often are they used? It is something that, for investors, is of extreme concern because of the reasons he pointed out. If they are going to put a significant amount of money at risk over a long period of time in a fairly high-risk technology development exercise, they need some assurance that that investment, if they are successful, would be protected.
I would have little to add to those particular comments, just to say that I think the standard recourse for purposes of saying compulsory licensing is bad is it defeats investment-backed expectations at the front end.
Quickly, Dr. Riley, the red light's about to illuminate.
It's
It
already
has
on there.
illuminated.
One point about it, the cost, as you mentioned in your opening comments, the cost of getting a new drug to market may well be $1 billion. What we're talking about, what I'm really addressing, are diagnostic genetic tests, the cost of which to take from the association between the clinical condition and the sequence that's done in the university and then licensed out, for have the laboratory to bring up that test, that might be anywhere from $25,000 to $50,000 to, at most with new technologies, maybe $250,000. It's not the same investment that we're talking about with therapeutics. It's very, very different.
I yield back, Mr. Chairman. Thank you.
Thank you. We'll have a chance to explore that specific subject you're raising later on the third and fifth rounds of questioning. Mr. Asa.
Thank you. The fifth round is where I get my really tough questions in. You know, I looked for something that was akin to this subject. You know, when did we discover something and grant it a patent? And oddly enough, I found something that was a little bit close, and that was when the product now known as Botox took something that was commonly understood and said, but you can do it for this, do what it does, and you can do it for this reason. And it was granted a patent and continues to be a ever more broadly successful product, including for people with migraine headaches now, which I think Congress should figure out that Botox is the antidote for what we do. So, I mean, I see the importance of it, and I guess I'll ask two major questions. And one of them, Dr. Grodman, this is Coca-Cola. It's a secret. Nobody knows what it is. If we don't grant patents, and I understand that you support the patents, but just because you support it and yet have a problem with the exclusion, if we were to not grant patents in this area, would it be a little bit like this, except we wouldn't see it in the marketplace? People would discover and then continue to keep it a secret so that they could do the follow-on work. Isn't that a risk we take when we don't patent something which we want discovered, but it could be discovered and kept a secret? And, for example, diagnostic centers could preclude you from knowing what you need to know. Well, they know what they need to know and say, just send it to us, and we'll tell you whether you've got this fatal disease.
Well, I would probably be scarcely the last one on this panel who would be championing patents. I think that in the medical arena, we do know what the formula, if you will, of within Coca-Cola is. It's been well researched and referenced in medical journals. The question is whether or not we're able to go in and have access to the different information. So I'm by no means supporting or, for my purpose today, supporting or not supporting patents. What I am supporting is the fact that there needs to be competition, that when we have certain information about diagnostics, that people can compete over producing a better test. My own preference is that the information is open and that people do benefit. In a system of what I'm addressing, that license for Coke, it's the best one there is and everyone knows what it is, I'm saying fine, but pay them a license if you want to be able to do it, but be able to allow everyone to be able to enjoy Coke no matter what the outside bottle may
So
look like.
essentially, you've got to be making the argument for a patent, otherwise there'd be nothing to license, it'd just be a secret.
I'm not making a case for or against patents. My concern is the ultimate amount of patient care and creating the competition for the exclusionary idea that people can't perform a test.
Mr. Sung, I guess I'll switch to you just to see if I can get a dissenting opinion. If we, in fact, deny patents in this field, don't we induce universities, perhaps the private sector, because universities might choose to publish regardless, but don't we induce people to cloak discoveries in a way that allow them to further their business practices without ever releasing it? Couldn't you end up with 5 or 10 or 20 different research facilities discovering the same thing, but keeping it to themselves? Because if they can't enjoy a period of patent protection, they might as well enjoy a period of exclusivity through non-disclosure.
No, I agree with those comments. I think that what you are risking if you were to deny patent exclusivity in a particular area is to risk that without that encouragement for disclosure, that there may be, I guess, more of a motivation, if you will, towards keeping something secret for a business purpose. But that would depend in a particular industry on the various market and business approaches. But I do agree that you would be removing the encouragement for disclosure that the patent system was designed to protect.
And Dr. Grodman, I'll go back to you with I'll get off of Coca-Cola for a moment. I was an electronics manufacturer with now hundreds, but in those days 37 of my own patents. And I made it a practice not to license anybody. I made it a practice to produce my own products and to provide a superior product based on my patents. Why is it you think that a medical diagnostic company, whether or not they invented it or they licensed it, shouldn't have that same ability to do it? And why do you think that it per se causes them not to want innovation? Isn't their clock ticking? And that if there isn't an encouragement by the licensee to get the inventor to invent more and to continue, if that encouragement isn't there by the large dollars and the ticking clock on the patent, why wouldn't that, in fact, induce good development and good products?
I would argue that that is not necessarily the case when it comes to medical diagnostic or in genetic diagnostics. That when you go in and have an area which has a clinical association, what you're really doing is not patenting a product or something that you're going to sell. You're patenting an association, whether it be for a type of arrhythmia in 3 or 4 different genes. And if you go in and you'll do that test, if you do it without competition, you'll perform that test, and if people have that, they'll have nowhere else to go for that answer. Let's say someone else goes in and says, you know what, there are 3 or 4 other genes that we can discover that will help make those original genes, make the answer clearer, better, delineate those who are at risk, maybe what medicines they need to be on or not. That innovation, there's no possible way that those other genes can be done, or tests can be done on those without getting a permission or a license on the original genes. As a result, innovation in that case gets to be stifled, and patient care is affected. If the second group of people had a license to perform those tests, they can go in and make the ultimate test better. That would be lost if only one person had the innovation. The example in the testimony that we gave about where there were certain genes about breast cancer that were done, but over 10 years, it took 10 years of time for the one company that had the exclusive license to include those other genes to help make the test clearer for risk of breast disease. In a competitive framework, that would not be the case. I would argue that the genes on products or patents on products or drugs is different than in this case in the diagnostic association between a clinical condition and a sequence. That there are fundamental differences which makes it important for people to be multiple people to do the test.
Thank you. I yield back.
I think do a second round. I think it's, I have a couple questions, but let me just make sure I understand. You're not arguing for these purposes, whatever you might think otherwise, but you're not arguing to nullify gene patents. Is there something, explain, any of you, is there something different between a patent on this segment and a patent on a diagnostic, a genetic diagnostic test? Are those two different? In other words, you're not, Dr. Soderberg, you have a test.
No, sir. They are essentially the same. In fact, were we as universities to have that competition on the front end where there are multiple companies that are interested in commercializing these products, that would be a great thing. That is not often the case. In fact, it is seldom the case with universities. In part, and this is another misconception, we often think of there is a patent and there's a product. And as you know from your experience in the patent, those two things are not necessarily equal. And in fact, oftentimes we are in the business of aggregating technology so that we can create the product. And that's one of the misconceptions. And so while I admit that there have been some examples where we probably, as universities, could have done licenses differently in hindsight, it's oftentimes we're not in that admirable position. We're looking towards trying to induce somebody to invest in the technology and trying to bring it into a product form as quickly as possible. So we do take a nuanced view. We don't necessarily always grant across-the-board licenses. We divide it up into fields of use, for example.
But be real, for me, I want to really get it down so simple that I can pretend to understand it. I think of a medicine, and biotechnology produces medicines, and then I think of tests, which determine whether or not you have something, or you have a predisposition to something, or the genetic makeup that might lead to that higher likelihood of getting something. Is it, you're saying, I guess, and that's why I'm wondering, should I be thinking about patents in the context of these two different things, or is it all blur into one?
Ultimately, they're the same. They're products that embody claims to a patented invention. And to the extent that you deliver that in a pill bottle, or to the extent that you deliver that in a set of reagents that are going to be mixed with a patient's blood and then spotted on a slide, they're no different.
In other words, they may have different goals, treating versus diagnosing, but
when we are presented with a discovery of a new gene that affects a disease category, there are usually 4 different sets of claims that you write for it. One is the use of the protein that is expressed as a therapeutic, the gene itself as a potential diagnostic, the gene potentially as an antigen that would be used in a vaccine or other prophylactic, and then the third is as a research reagent for discovery of other things. Those are the 4 major claim sets on all DNA-based sequences that we typically use. How they
it's sort of boilerplate.
It's pretty close nowadays, yes. It's fairly routine. It's still expensive, but it's become much more routine.
All right, well, then just, I'll get at least one of the questions I wanted to ask originally before I went down this road. Mr. Cushman, why wouldn't bio support the use of march-in rights in the kind of case that Dr. Grodman's talking about, where the need to have others provide genetic tests is great? Again, I guess some of that depends on how I understand the questions I was asking you. Can you have march-in rights for this? I guess march-in rights exist, they're just never utilized, but can we encourage the use of march-in rights in this sort of subset of an area where the investment isn't billions, it's thousands, tens of thousands, hundreds of thousands, to achieve the kinds of purposes that Dr. Grodman was talking about?
Well, I think your earlier question is getting to the challenge that is at the root of this problem. The patents that issue are going to have claims on nucleic acids corresponding to a gene that discovered something. That patent right, that single patent, is going to protect many different potential applications. One might be development of a method of making the protein, which then becomes a drug. Another might be used in this clinical diagnostic setting where you're going to be screening and trying to determine if that gene is present in a sample. Another, application may be, I don't know what another application might be, but for the purposes of this process, you're talking about the single patent. putting a condition through Marchand rights on limiting the use of that patent right is the thing that causes concern within the biotech sector. The idea that at the back end of the process, once you've reached the market, there's going to be a government-mediated decision to limit those patent rights. That's, I think, the chilling effect that I was trying to describe before.
Yeah, well,
I think,
I'm sorry.
no, I think one of the other questions that I wanted to address is just, can you address the concerns that have been raised in these settings of clinical diagnostic use versus patent rights in product development? I don't think you can do that cleanly through the patent system or by limiting patent rights. One of the things we always like to point out is that the patent rights are rights over the invention, and if there's conduct or other types of conditions that are seen in the market regarding the behavior of these companies, there are other ways of addressing that other than through the patent system. And I guess that's one question to tackle, is whether that's something that's worth looking into.
Mr. Coble.
Thank you, Mr. Chairman. Mr. Cushion, since you're firing away, I'll come back at you with a two-part question. What is your opinion of the biotech examiners at PTO, A, and B, are they approving overly broad biotech patents similar to what occurred with business method patents in the late 1900s, 1990s?
Well, I was at one point in my life a biotech examiner, and I think for that sector of the patent office, I feel like those patent examiners probably are on the higher end of the scale of experience and training of most patent examiners. They typically come out, many of them have PhDs. They're probably the best of the group over at the patent office, based on their training experience, et cetera. I think the patent office is doing the best job I've seen of really tying down our patent claims. I think anybody who works in the area of getting patents out of that group can share my pain of saying that the claims that you emerge with are often viewed to be exceedingly narrow, driven by both the strictness of the examiner's perspective and how the patent office uses these significant cases that have come down. And that goes to one of my comments in my testimony. This is one area where you're not talking about a patent that should not have issued. These are patents that are meritorious, they're narrow, they match the contribution in the patent application. And so that's why we're looking at these rights with great interest. They're very strong patent rights that should be respected.
Thank you, sir. To either of the other three witnesses, gentlemen, to what extent are patent pools used today, and should the Congress do anything to encourage their use?
Congressman, the use of pooling of patents has become much more routine on university parts, but probably the most impressive one is the pharmaceutical industry's patent pooling on SNPs, the small repeated segments, or unique segments in genes that we find. It has become for a reality for most of us in licensing technologies that we only own a small part. In part because of what Mr. Cushion just said, which is our claims have become significantly narrowed. And that is a significant reality in the last 6 or 7 years, that it has become much more difficult to get broad claims in the patent office. And for that reason, we're oftentimes, in my case, at my university, it's a very frequent, probably 10 to 20% of the time, we are putting together intellectual property, not just from Yale, but from other university colleagues to try to put together a package which then could be licensed. It's not difficult to do. It has become relatively routine, and I don't see it as being a significant barrier to entry for a product.
Yes, sir.
I can't comment on what it's like in the academic environment. In the commercial environment, it's simply, it's a noble attempt to be able to overcome a problem, but it's something which has not taken hold. I mean, there are many cases in which we can talk about where some genes will diagnose a condition and 3 other genes may diagnose it better or differently. And in those cases, there is very little camaraderie or ability to be able to share information, often when that happens, causing conflict. It's a noble attempt, but it hasn't helped in the diagnostic arena in a commercial environment.
Dr. Sung, you want to weigh in before my time expires?
Only to say that what we have here as a result for looking at patent pools is that DNA is a de facto industry standard for biological sciences. You can't wake up tomorrow and say, I won't use DNA for these purposes. And so for that reason, the ability to design around in this field is very different than you might see in other mechanical or electrical technologies where patent pools first grew up. So I think there is a need for this in many instances to consider more heavily.
Thank you. Thank you, gentlemen. Yield back, Mr. Chairman.
Mr. Ice, here's my problem.
Yes, sir.
I have to go to the DOD Authorization Conference Committee to push language that the Foreign Affairs and Judiciary Committees are both recommending on the issue of Iraqi refugees. They want me there now for this conference committee. My inclination would be to give either of you the gavel to let you keep going, but I'm told I'm not allowed to do that.
Yeah, Ken Kucinich got in trouble for doing that, too.
Gave it to a Republican?
Give it to me.
Oh, gee.
And I didn't even abuse it. Okay, you want me to wrap up?
So if you could be, I mean, the fact is I have 5 or 8 more questions I want to ask all of you, but I'm not going to be able to do it during this process. I would hope you would allow us to be in touch with you to pursue some of these things, because we've just sort of, in some cases, touched the surface. And we intend no commercial use of our research.
Thank you, Mr. Chairman, I'll be quick. Dr. Soderstrom, there was an earlier statement that somehow patents were barring people from doing follow-on research to discover new genes. In your experience, is that incorrect?
That is incorrect.
Okay, so you don't feel, Yale University doesn't feel that even if somebody over here has an exclusive license, that you read the patent, that it allows you to take what they've done and look at it for your follow-on work. You just can't incorporate it in your later release. Would that be fair?
2 points. One is there is no tendency to look at patents prior to conducting research at Yale. University faculty members are free to pick any area of inquiry. Second, in terms of the discovery that they ultimately make, we do novelty searches to see if there is other intellectual property.
Sure.
And in those cases, we may choose not to patent simply because we don't see the point, and we would just encourage publication as soon as possible. If we do think that it would be a significant improvement, we usually would approach whoever has the exclusive rights.
Okay,
as the
now,
first point.
this is an academic question, but for me it wasn't academic. My experience has been that exclusivities, being excluded from somebody's invention, caused me to, in fact, figure out a way to skin the cat differently. I'm not in your industry. I'm not in your academic endeavors. But isn't it somewhat true in all areas of endeavor that what you do not have access to, and Dr. Sung, Larry, I saw you perk up on this, so you get first thing. Isn't it true that in a sense there is a benefit to exclusivity, which causes people to go elsewhere and discover other things or around it? Isn't that an experience that even in medicine goes on?
Well, I do think as a generality, the patent system is designed to encourage design around efforts and forward progress as a result of those efforts. I do think that in certain instances, again, because we're talking about genomic information here, the ability to do so may be somewhat stricter and harder to do. So I think there are instances where there may be blocking patents that might issue to this that are impossible as a technological matter to design around.
Okay.
But I think your general proposition is correct.
And isn't the pooling that's gone on to a certain extent the result of those blocks causing people to go to other areas, create, if you will, block backs that then lead to the pooling being a necessity so that you have an ability to invent in an area in which very little is known? I'm seeing yes here, Doctor.
That's certainly been our experience. That's what we've recognized because people see it as a utility, as an opportunity to get around some of the things that are blocking them.
Same?
Sort of a
No, I would disagree with that.
So we only have 3 out of 4. Okay.
Guess so.
That's- You know, that we can get a suspension passed with that here. Time is limited for the chairman, too, so I appreciate that we sort of have a disagreement, but at least we got that out as to what the value of exclusivity is. potentially. Thank you, Mr. Chairman.
All right, with great regret, I have to adjourn this because of the way this place works, but I do appreciate your coming, all the efforts, particularly some of you made from coming a ways to testify, and we will be following up individually and perhaps with questions. Thank you very much.